The United States Supreme Court has denied Special Counsel Jack Smith's request to hear oral argument at this stage in the criminal case after a Washington, D.C. federal judge, Tanya Chutkan, denied Donald Trump's motion to dismiss the criminal indictment against him when Trump was trying to assert absolute presidential immunity. Let's just break it all down what this means. I'm Ben Meiselas from the MeidasTouch Network. First, let's talk about the order by the United States Supreme Court. Then I want to explain why, for now, I don't think this is a big deal. I don't think you should worry yet. And for those who have watched the MeidasTouch Network, you know that I predicted this is what was going to happen based on the fact that the D.C. Circuit Court of Appeals has expedited the appeal process on this same issue of absolute presidential immunity. So first, let me show you the United States Supreme Court ruling here. Then let's talk more broadly about what is going on. So just moments ago, this order hit. We saw the Supreme Court docket reflecting a denial of Special Counsel Jack Smith's direct request. Formally, what Jack Smith was seeking was called a petition for a writ of certiorari, oral argument, in other words, before the United States Supreme Court. The Supreme Court ordered that Donald Trump provide his position by December 20th about whether or not oral argument before the Supreme Court on the issue of absolute presidential immunity should take place on a direct appeal. Special Counsel Jack Smith issued a reply, and here on Friday, December 22nd, we see right here, petition for a writ of certiorari before judgment is denied. And then we just got a one-sentence order from the United States Supreme Court. Here it says United States versus Trump. The petition for a writ of certiorari before judgment is denied. That's it. That's the full order. There are no dissents being reflected here. And I want to explain why I think that is as well. And I also want to explain why this does not concern me yet. So just to be clear, what this relates to is the fact that in the Washington, D.C. federal criminal case against Donald Trump, which is set for trial on March 4th, 2024, the federal judge, Judge Tanya Chutkan, denied Donald Trump's motion to dismiss the indictment in that federal criminal case being prosecuted by Special Counsel Jack Smith. Donald Trump was seeking to dismiss it on the grounds of absolute presidential immunity. Federal Judge Tanya Chutkan denied Donald Trump's motion to dismiss on absolute presidential immunity grounds, and Her Honor found that based on the text, structure, and history of the Constitution, former presidents cannot assert absolute presidential immunity in criminal cases for criminal conduct they engage in while in office. Donald Trump filed an appeal to the D.C. Circuit Court of Appeals. He also requested a stay of all proceedings before Judge Tanya Chutkan in the District Court. Federal Judge Tanya Chutkan granted Donald Trump's stay as Donald Trump's appealing before the D.C. Circuit Court of Appeals. Special Counsel Jack Smith then sought two things in response. First, an expedited appeal before the D.C. Circuit Court of Appeals. That was granted. Separately, Special Counsel Jack Smith sought a direct appeal going around the D.C. Circuit Court of Appeals directly to the United States Supreme Court. The way this usually works in almost all cases is you got to go through the different levels. You don't just take the elevator to the penthouse, or in this case, the Supreme Court. You start at the District Court. That's Federal Judge Tanya Chutkan. You go to the District Court's bosses, in this case, the D.C. Circuit Court of Appeals. And then you go to the United States Supreme Court if the Supreme Court ultimately grants what's called certiorari and hears the case. But there is rare instances where there's cases so extraordinarily impacting our democracy and require such urgent attention that you can go around the D.C. Circuit Court of Appeals or any of the other sister circuit courts of appeals and go directly to the Supreme Court. Special Counsel Jack Smith argued to the United States Supreme Court, despite the fact that the D.C. Circuit Court of Appeals is expediting this, we need you to hear this right now. There's a March 4th, 2024 trial date, and Judge Chutkan is staying the proceedings. This is one of those extraordinary cases impacting our democracy. Donald Trump responded with an opposition to Special Counsel Jack Smith's petition, and Trump and his lawyers argued, and this is a direct quote, "Haste makes waste." And they said, Supreme Court, you don't need to address these issues here. Look, the D.C. Circuit Court of Appeals is dealing with it, and then maybe after that, the United States Supreme Court, you can deal with it. But this is not one of those extraordinary circumstances where you need to step in. Special Counsel Jack Smith filed a reply and said, nope, this is one of those special cases, and now the Supreme Court has ruled and has denied Special Counsel Jack Smith's relief for now, has denied Special Counsel Jack Smith's petition for certiorari, which just means oral argument on the issue of absolute presidential immunity. Now, why I'm saying that I don't think we should worry yet is because the D.C. Circuit Court of Appeals has ordered expedited briefing, has ordered an expedited appeal before it. Let's take a look at what the D.C. Circuit Court of Appeal previously ruled. Here's what it ruled on December 13th, 2023. The following: upon consideration of the motion to expedite the case, the opposition thereto, and the reply, it is hereby ordered that Trump's brief before the D.C. Circuit Court of Appeals be filed December 23rd, 2023. Special Counsel Jack Smith's response, December 30th, 2023. The reply brief by Donald Trump due January 2nd of 2024. But the D.C. Circuit Court of Appeals was not done yet. And this three-judge panel in the D.C. Circuit Court of Appeals then ordered oral argument on Donald Trump's appeal of the denial of his motion to dismiss the federal criminal indictment in Washington, D.C. on grounds of absolute presidential immunity for January 9th, 2024. So within a short period of time from now, oral argument will be taking place before the D.C. Circuit Court of Appeals, and I think they understand the urgency of this issue. They understand that they need to be handling this in an expeditious manner, especially because of the stay taking place in the district court. Also, if you look at the three-judge panel, in terms of a pro-democracy, law and order, no-nonsense panel, you've got a great D.C. Circuit Court of Appeals panel that will be looking at Donald Trump's appeal of federal judge Tanya Chutkan's denial of Donald Trump's motion to dismiss the indictment on absolute presidential immunity grounds. You've got Judge Childs, you've got Judge Pan, and you've got Judge Henderson. You've got three law and order, no-nonsense judges who I'm very pleased to have as the panel here. So how was I able to predict that this is what the United States Supreme Court was going to do? And why do I think my prediction aligns with why we see no notable dissents in the order of the Supreme Court denying Special Counsel Jack Smith's relief for now, Jack Smith's request for certiorari or oral argument? I think the Supreme Court looked at what the D.C. Circuit Court of Appeals was doing, that the D.C. Circuit Court of Appeals was expediting this, that we should have an order by the D.C. Circuit Court of Appeals, I believe, denying Donald Trump's request or affirming what the district court ruled, affirming that Donald Trump does not have absolute presidential immunity. So I think the Supreme Court said, why would we exercise this extraordinary jurisdiction right now and get involved if the D.C. Circuit Court of Appeals, remember that normal steps, the steps I was talking about, you don't take the elevator to the penthouse, usually you don't go right to the Supreme Court. Let's let it get to that next step. The D.C. Circuit Court of Appeals is moving very quickly. They should have an order. I mean, this isn't in the Supreme Court's order, but reading between the lines, this is what I think happened, that there should be an order probably mid-January, late January, and then the Supreme Court can ultimately decide if it will take oral argument on this. Now, one of the key things then that we have to figure out is, will the D.C. Circuit Court of Appeals then stay their judgment, stay their mandate pending a writ of certiorari to the United States Supreme Court. And will that cause further delay? And then ultimately, will the United States Supreme Court at that next level, which I think will be probably sometime late January, early February, will the United States Supreme Court then decide to grant certiorari and expedited briefing? Will they decline to grant certiorari? What's the D.C. Circuit Court of Appeals going to do? Are they going to stay all of these proceedings, or are they going to send the case back for trial to the district court? So that's why I say we shouldn't worry yet. Now, in terms of delay, do I think the Supreme Court not hearing this on an expedited briefing could cause further delay? The answer is yes. Do I think the delay will prevent this case from going to trial in 2024 by the Supreme Court denying Special Counsel Jack Smith relief here? I still think there's every indication that this case can be heard in 2024 based on the landscape that we have now. As I've said, after Judge Tanya Chutkan granted the stay in the district court proceedings, and after the D.C. Circuit Court of Appeals, though, agreed to that expedited briefing, I was saying I expect an order by the D.C. Circuit Court of Appeals affirming the ruling by the federal judge Tanya Chutkan denying Donald Trump's absolute immunity argument. I expect that to hit sometime mid to late January, maybe February 1st, the latest. Then I think you'll see a renewed request by Donald Trump for certiorari before the Supreme Court. Then the question is, does the D.C. Circuit Court of Appeals stay the proceedings? Then what does the United States Supreme Court do? Will they hear it then? But ultimately, there is a clear path for this case to be heard in 2024. And I think Special Counsel Jack Smith was aware that this was probably, I think he would have liked the Supreme Court to hear it, but I think Special Counsel Jack Smith realized that was the result that was likely going to happen. But nonetheless, because Jack Smith operates from a place of principles to basically say, hey, we need to address this issue right now. We need to make sure you hear it because it is that urgent. It is that important right now for our democracy. Now, I want to address kind of one more, I think, kind of fundamental issue that we have to see what happens next. After the D.C. Circuit Court of Appeals denies the relief that Donald Trump is seeking after oral argument, as I mentioned, the key question is ultimately going to be whether or not this panel stays the proceedings. And what will the Supreme Court do at that point in time? So let's wait and see that. Oh, the one other thing I wanted to mention is, again, that's why I think you don't see any dissents in the United States Supreme Court. I think all the justices were aligned. Hey, the D.C. Circuit's moving quickly on this appeal. Let's let the D.C. Circuit Court of Appeals rule. Then we'll decide whether we take certiorari at that point. But let's not go around the normal structure of things. And there's still a ton of time for this case to be heard in 2024. So I think that's where the Supreme Court erred. Now, I'm sure you believe that this is frustrating and we want the Supreme Court to hear this right now. I would like the Supreme Court to hear this right now as well. But I think that they've engaged in a little bit of judicial abstention right now as they see what happens at the circuit court level that's moving at lightning speed. So let's take a look at what the next filings are by by Donald Trump, by Special Counsel Jack Smith. Oral arguments right around the corner, January 9th. Then we'll be in a position probably mid-January, late January, the latest, I think, early February, where we are right now. So a little more delay, but this trial is not going to be derailed in 2024. The trial, I said, once Judge Chutkan granted the stay, it's never going to happen on March 4th, 2024. I predicted kind of more late April, early May would probably be the schedule for it right now. And remember this, that probably means that the Manhattan District Attorney criminal case for Donald Trump's hush money payments, which is scheduled for March, that may be the first to go. Then maybe this one goes after, and then you have some of the other trials. So we will keep you posted here, but I wanted to give you that full analysis of everything that's going on. Hit subscribe. We're on our way to 2 million subscribers thanks to your support. And check us out at patreon.com/MeidasTouch and have a good one.
Hey, Meidas Mighty. Love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.